good afternoon, and to the audience, and just excited again to bring about another edition of the Next Level Advisor. And today we're going to have a guest that we've had on our podcast, which is Andy Weinhaus. Andy, good to see you, my friend.
Yeah, good to see you too.
And then today, Andy, this is really hot off the press. And this is the reason we are actually kind of like doing this unscheduled podcast is because something actually has taken place, which obviously has great importance to a lot of advisors, but more specifically clients that are business owners. And Andy, just to kind of I'm going to do a very quick recap, but I want you to explain what this all means. So this was a recent decision made by the Supreme Court, and you can talk about the Connelly versus the United States concerning closely held corporate-owned life insurance and how it's funding both redemption and entity buy-sell agreements. So something has happened here, and can you talk about what happened and what this all means?
Yeah, thank you. Yeah, truly hot off the presses. Less than a week ago, the decision came out, and the name of the case is Connelly, and it's rare, not completely infrequent, but rare that an estate tax issue under Chapter 11 of the Internal Revenue Code gets in front of the Supreme Court. And just to kind of synthesize things, the Connelly owned a building supply company, two brothers, and they had a redemption agreement. Really, it was a redemption agreement where the entity itself, the corporation, owned life insurance, a $3 million policy in this case, and the taxpayers, the Connelly family, tried to exclude that $3 million from the valuation of the business, the shares of the business that the late Mr. Connelly owned, to bring the estate taxes down. And magically, magically in quotes, the IRS objected to that and said, no, that $3 million should be included in the value of the business. It's owed to the business at the instant of death by the life insurance company. And we feel that we're owed estate tax on that extra $3 million, as it in a sense kind of ripples through the value of the business. And the Supreme Court, 9-0, no questions about it, said IRS is right on this one. At the instant of death, that death benefit is owed to the corporation. This was a redemption agreement where the shares were going to be redeemed out by, let's say, the deceased shareholder's family, widow, children, whoever it's going to be. And that $3 million has to be included, willing buyer, willing seller, even though they were brothers, in the valuation of that business. So 9-0, no dissent. There is no dissenting justice's opinion to read. We're left with this is it. And it does have big implications, Ed, going forward for the structuring of buy-sell agreements, especially for those families where a shareholder might face the estate tax at death.
So Andy, let's talk about that, because the implications here or the impact to business owners, obviously with certain types of agreements, and I'm assuming there's some agreements that would not have implications here, but what does this mean? You're talking about valuation. It looks like there's an increase because of the funding of life insurance to that. What does this mean from a federal, estate, federal, state, and estate tax purposes? What does this all mean?
Yeah, a lot, Ed. As we've been talking about, thanks to you guys on behalf of Pinnacle, we are staring at a very significant reduction of the estate and gift exemptions. We've been talking a lot about gifting this year and using gifts to use, I'll put it this way, your extra 7 or 8 million of gift exemption that might go away in 2026. But it's that same exemption for estates as well, for the estate tax. And that also might drop precipitously if the current, I'll put it this way, Trump-era law sunsets on January 1st of 2026. And for those with a large portion of their potential taxable estate made up with business interests, this really matters, especially if you have a redemption agreement funded with life insurance, where a life insurance policy is absolutely a long-term asset on the books of the corporation. This could make a big difference, and we would, as a counsel, for me, as a member of the Missouri Bar here in Missouri, I will be looking at alternative structures for buy-sell arrangements when I have a client that might face the estate tax.
So, Andy, as you're speaking to that, certainly we can talk more about this in depth at another podcast, but just on the surface, what are the other considerations that one should be looking at, or in this situation?
Great question, Ed. Yeah. So in addition to entity-based buyouts, we oftentimes have shareholder buyouts where, let's say, if this had been structured differently and the Connelly brothers, one brother had owned a policy on the other, and they each owned a policy on the other brother, when one of them died, the death benefit on the one that did die is not owned by the corporation and is not owned by the deceased brother. So it's not included, in this case, in his gross estate. All that would be included is the value of the policy on the surviving brother. And that's something, I don't want to bore people to tears, that we call the interpolated terminal reserve. And that's far, far less than the $3 million death benefit in this case. It would have resulted in much, much less estate tax for the deceased Connelly brother. That was one of them that owned shares in the corporation, this building supply corporation.
So you also talked about valuation and business valuations. And this is also an area where, and again, we don't have to dive in too deeply, but you've got business valuation. That's got to be done correctly. That's something, do you often see where valuations are not done properly? And
yeah, I mean, it's going to be very clear for valuation firms now that they are not, at least with a corporate redemption, going to be able to exclude the life insurance death benefit from the value, in a sense, of the business. And even though the valuation firms and certified public accountants always thought, well, there's this corresponding liability. That was kind of the crux of won't bore people to tears. That was the crux of the Connelly family's argument that, wait a minute, there's a liability owed by the corporation, let's say the widow or the deceased party's family members. That's not the way the Supreme Court saw it, 9-0. No. This willing buyer, willing seller, and that policy death benefit is a corporate asset at time of death that has to be taken into account for estate tax purposes.
Wow. So in a nutshell, Andy, what do business owners need to do? I mean, what would be the call to action for them? And
get with their pinnacle representative, their financial representative, and say, this is how we've always had it. Yeah, we did have a redemption agreement. What should we be doing instead? Should we be looking at alternatives? And it's going to involve their local counsel and maybe even their accountant, their certified public accountant as well. Get those folks together to powwow, Ed, on if, in a sense, maybe a change to the form of business succession agreement is appropriate.
So what is necessary is a review. Certainly, they've got to review what agreements may be in place, how they're being funded specifically, and then looking to see what are some of the options and alternatives, which they do exist. Depending on the structure of the corporation, there's opportunities to be able to leverage what has taken place here. But again, it requires a need to act in review and then coming forward with potential options that we can look at.
Correct. And I always remind people, Eddie, it's not just the value of the business that goes into the estate tax calculation. It's that deceased party's residence or a vacation home or a brokerage account or IRA and retirement plan. It all goes in. It's kind of like a snapshot of what somebody was worth on the date of their passing. And that's how the IRS expects estate tax to be calculated.
Andy, listen, this was a very quick, it just happened last week. I wanted to get your opinion, to get your thoughts on this and get this out to our audience as quickly as possible. We're going to kind of reconvene another time to really go into some of the strategies that can be considered at this point. But first and foremost, thank you as always, being readily available, being accessible, and really addressing particularly a topic that's coming right out of the Supreme Court. Appreciate you, and looking forward to reconnecting with you very soon.
Sure. Thanks, Ed.
Thank you.